Good morning. I'm going to call to order the public meeting for today, July 31st, 2018. To my left is Ron Carl, the county attorney. To my far right is Jolene Sanchez, the assistant clerk to the board. Ms. Sanchez, would you please call the roll?
Commissioner Jackson?
Here.
Commissioner Holland?
Here.
Commissioner Sharp?
Here.
Commissioner Conti?
Good morning.
Good morning. Commissioner Baker?
Here. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Mr. Carl, are there any modifications to the agenda this morning?
There are no modifications, but I would like to point out that one of the items on your consent agenda, item 6D, is the approval of the County Board of Equalization referee decisions. And a copy of those decisions was emailed to the board yesterday afternoon, and copies have been provided for you today on the dais, and I've given a copy to the deputy clerk for entry in the record. If you have any questions or concerns about the decisions, then I would recommend you pull this item and put it on your general business agenda, but if not, it's okay to leave it on the consent agenda. And I would also like to acknowledge once again all the hard work that Karen Thompson and Barb LeBlanc did in my office in running the CBOE process. And again, it went really well this year, and they should be commended for doing such a great job.
Agreed. Thank you, Mr. Carl.
A lot of work. Thank you.
We appreciate it. If there are any motions to make in reference to that consent agenda item, I would entertain them, or I would entertain a motion to adopt the agenda. Commissioner Holman.
Mr. Chairman, I move that we accept the recommendations of the Adjustment Board, and
It's really just to
Whether to move it to the general business.
yeah, I'm sorry,
Or
move it to the consent agenda.
Or leave it on, it's already on the
Okay.
consent agenda.
Okay, so there's been a motion made that we allow the BOE decision report to remain under the consent agenda.
I'll second that.
Seconded by Commissioner Sharp. All in favor?
Aye.
Aye. May I have a motion to adopt the agenda as stated?
So moved. Second.
Motion made by Commissioner Conti, seconded by Commissioner Holland. All in favor? Aye. That motion passes unanimously. Let's see. We're going to move to the general business items. And we have, oh yeah, the minutes. We have to approve 3 sets of minutes. The first 2, we had a full board. That's for June 26th and July 3rd. We had on both those days we had a full board of county commissioners, and then on the last one, July 10th, Commissioner Jackson was absent and excused. So may I have a motion to approve the minutes or any discussion concerning the minutes of June 26th?
I so move.
Motion made by Commissioner Holland.
Second.
Seconded by Commissioner Conti. All in favor, please say aye. Aye. Any discussion or any motion regarding the minutes of July 3rd?
I'll move approval.
Motion made by Commissioner Sharp, seconded by Commissioner Holland. All in favor? Aye. And the last set of minutes are for July 10th. And again, Commissioner Jackson was absent.
I'll move approval.
Motion made by Commissioner Sharp, seconded by Commissioner Holland. All in favor?
Aye.
1 abstention. That motion passes. This is the time that we've set aside for any public comment. If there's any public members of the public, any citizens here that would like to address the Board of Commissioners on any issue that's not on the agenda, please make yourself known to me. Seeing none, we'll move on from that to our general business items. We have 1 public hearing. Oh yes, I'm sorry. We approved the agenda. We have to approve the items on the consent agenda. So may I have a motion to approve the items on the consent agenda?
I so move.
Second.
Motion made by Commissioner Holland, seconded by Commissioner Conti. All in favor, please signify by saying aye. Aye. That motion carries unanimously. This is public hearing W17-003, Subdivision Exemption Code Amendment. And our presenter this morning is Jason Reynolds, the current Planning Program Manager. And our attorney on this item is Robert Hill, the Senior Assistant County Attorney. Mr. Hill, good morning. And do we have a foundation that you can set for us on this?
Yes, thank you, Mr. Chair. This request to amend the Land Development Code, the subdivision and the exemption portions within the subdivision code, has been properly noticed by publication in the Villager and the Scout. Board has jurisdiction to proceed.
Thank you very much. Good morning, Jason.
Good morning, Mr. Chair, members of the Board of County Commissioners. Today we're considering a code change for the subdivision exemptions set of the code. And a subdivision exemption is established as a power for the Board of County Commissioners in state statute that allows the board to, in certain cases, exempt land from the strict application of the definition of subdivision. It's typically used when land is used for a public purpose. For example, fire stations, parks, and schools may seek subdivision exemptions rather than following a normal subdivision process, and also for correcting improper divisions of land. And it's the improper divisions of land that sort of prompted this proposed code change. We appear to have a lot of improper divisions of land, and I'm noticing that the PowerPoint is not showing on the screens, but so I'll just talk to the slides until it shows up. Our existing exemption process only allows corrections for parcels that meet our zoning standards. There it is. I won't totally read from the slides anymore, but as an example, an A1 zone district requires a 19-acre lot. So under our current version of the exemption code, you have to have 19 acres in order to qualify for an exemption on that property in that zone district. And in a lot of cases, someone may have someone may have split off a parcel of land around an existing farmhouse that is far smaller than that 19-acre requirement. And just over the course of time, it may have transitioned to a number of other property owners without anybody realizing that it was improperly split from the remainder of the ranch. So you have this maybe 12-acre parcel surrounded by, another 19 acres. And that 12 acres just wasn't properly divided. So to correct that under our current code, we would have to process a zoning change to make the lot size legitimate, as well as a subdivision. Both of those require public hearings at Planning Commission and the Board of County Commissioners. The purpose of this proposed code change is to allow a less convoluted and less expensive process for folks who find themselves in that situation. And improper is something that was split after we adopted our subdivision regulations in 1972. If it's smaller than 35 acres in area and was not approved by the Board of County Commissioners, it ends up being an improperly subdivided piece of land. And county staff is prohibited from issuing any sort of permit on land that has been improperly divided. So that means no building permits, no additional garages, no decks. And in our research, we found at least 42 examples of improper divisions that are smaller than 10 acres in area, and about 375 potentially improper parcels that are larger than 10 acres in area. So that'd be from 10 acres to 34.999 acres, because 35 acres under state law, you can divide that without seeking any sort of approval. You just get a surveyor, split off 35 acres, and you're done. So I'll offer a couple of examples. This is an example of a 5-acre parcel. The house was built in 1985. The A1 zoning requires a 19-acre parcel. So to fix this, we would have to go through a zone change and a subdivision, and the applicant would need to spend somewhere in the range of $10,000 to $15,000 just on county fees, unless those fees are waived by the board. And the next item is a change to the fee schedule. The proposed fees for these are $1,000 each for planning and engineering, which is $2,000, significantly less than the cost nowadays. Thought I'd also offer a counterexample. This is an example of about a 2-acre parcel that was created in 1992 by the current owner. Somebody lived there for a number of years and then sold it back to the person who originally created that 2-acre lot. And that owner actually owns the 551 acres surrounding that 2-acre parcel. So this site would not be eligible for an exemption under the proposed regulations because they have a way to fix it. The same owner owns the 2 acres as well as the 500 acres. They could easily create a 35-acre parcel around this farmhouse and fix it without any sort of county process. So the proposed application fee, as I mentioned, would be $2,000. And we also have set it up so that the proposed exemption would not need to meet minimum zoning lot area requirements. As I mentioned, A1 requires a 19-acre minimum lot size. If an exemption is granted by the board, that minimum lot area requirement would go away, and it would also adjust the setbacks based on the size of the lot. So if a lot were, say, between 5 and 10 acres in area, it could benefit from the setbacks that are in the RA, which is one of the smaller zone districts. And that's because these smaller lots often would have difficulty meeting our agricultural zone district setbacks, which can be 50 or 100 feet or more, and that pretty much, a 2 to 5 acre lot can eat up the entire lot or most of it. And if the current owner created the improper division of land, they would not be eligible for an exemption under the draft regulations. And we presented this to the Board of County Commissioners as an idea at a study session in 2016 and 2017 and drafted the attached code based on input from the board. We presented this at the Board Planning Commission on May 15th, and on June 19th, the Planning Commission voted 6-0 to recommend approval to the Board of County Commissioners, and staff is also recommending approval. So I'm here to answer questions if the board has any.
Commissioner Jackson.
Thank you, and thank you for doing this. We've been waiting a long time as we see these cases come in front of us from time to time. I'm glad we're doing it. I think it's a great idea, but I have this question. Does this only apply to retroactive cases? So if somebody next year decides to carve off 11 acres somewhere, and then they say, "Oh, I didn't know I was supposed to do that," will this code apply to them at that point, or can we make this so it only applies retroactively, and from here forward, folks have to follow the rules?
Right. Excellent question, Commissioner. The code is not set up to necessarily say let me double check the language of the code here. I believe we have a section of the code that says after this insert adoption of the code date here, you would not be eligible.
So the parcel has to have been, or the lot has to have been created prior to the adoption of this exemption. And in addition, there's a provision where the owner of the property seeking the exemption wasn't involved with the creation of the illegal lot. So even if we didn't have that, if the person who illegally subdivided comes in and says, "I want to correct this," they would have to pay full fees because they were involved in creating the illegal lot.
Perfect, thank you. Obviously, I did not read the full report in detail, so I appreciate that. Thank you.
Any other questions for Mr. Reynolds? Yes, Commissioner Sharp.
What are the cons to doing this? I think there's some pros here for the landowners and who are kind of caught up in this, many of them inadvertently, but what are the drawbacks of doing this?
Certainly. One of the potential drawbacks could be that somebody could try to, game the system, because this is certainly a cheaper option than going through a subdivision. And one of the ways that we're trying to prevent that is by saying that one of the criteria is that the lot or parcel was created before the revised version of the exemption code. Another is that one of the criteria says that this is not just an attempt to go around our subdivision regulations. And that, I believe, will help prevent the potential for mischief with the draft code. But that is a potential drawback. It does give someone an outlet, and we may have some people try to use the outlet. Seeing a similar code in Douglas County, it had a similar provision about this shouldn't be used to just get around our subdivision regulations. And in that case, the Douglas County Board of County Commissioners actually denied an application that was attempting to do that. So it would be part of the staff recommendation plan, and we bring that to the board if necessary.
Great. So you all will be on the lookout for anything
Shenanigans
like that. So, Mr. Chairman,
Yes.
One other question. So how do we best communicate from this point forward because otherwise I can see us being asked to make exemptions after the adoption of this change. are there ways to better communicate or more effectively communicate to landowners? I don't know, sometimes it seems like they just do things and we're not even aware that those things have happened. So have you talked about those issues?
Right, and the landowners may not be aware that they're doing something improper as well. And so one of the things that I would like to do is, as I said, we have 400 and some candidates that could be improper divisions, but to research that requires checking the parcel birth date. That is, when was that parcel created? So we have to do that, coordinate that with the assessor several hundred times, and confirming that no previous exemptions were granted on that parcel. And, once we have that in hand, I would like to reach out to those property owners to let them know that there's an avenue available. Don't want to just send it out to everybody without doing the research, because then somebody's getting a potentially panic-inducing letter in the mail saying scary things about our exemptions, our subdivisions. And then going forward, our mapping division in Public Works and Development has reached out to the clerk and recorder to talk about ways that we could coordinate a little better to help ensure that somebody doesn't just create a legal description, walk down to the clerk and recorder, and record that legal, creating an improper split. Because that's, the property owners may not be aware it's happening, and currently the clerk will record those legal descriptions if you bring them to them. So we want to coordinate that a little better.
Sure.
So, yeah, thank you. So what does that mean, that the clerk and recorder would have to have some sign off by planning, public works, mapping, somebody to set before that? Is that what you all are kind of working on, that there has to be some approval before the clerk and recorder's office would record that?
Yeah, that's something we'd like to get there. Our mapping divisions had just some initial discussions about how we could, train the staff to try to catch these sorts of things. And as I said, it would require additional coordination between the departments, and it would probably be mapping or planning who would take a look at a proposed legal description so that it could be flagged as, be careful with this one. It might be causing problems.
I think that'd be really important to prevent this from going forward. So thank you.
Any other questions for Mr. Reynolds? If not, I would entertain a motion.
I'll make the motion here if I can.
It's on page 41.
Yeah, okay. Let me go back up here. There we go. In the case of 2018 planning fee schedule update.
Sorry, that's the next one.
Oops, am I on the next one already? Hang on, let me go back here. Okay. In the case of W17-003 subdivision exemption land development code amendment, the county commissioners have reviewed the staff report, including all exhibits and attachments, and have listened to the applicant's presentation. Oops. Was there anybody who wanted to speak on this?
Yeah, we really should open up. I'll go ahead. Was there anybody that signed up, Jolene? I'm going to open up public comment on this. Sorry to interrupt the motion. If there's any member of the public that would like to speak on this matter, please come forward. Seeing none, I'm going to close the public hearing. Please proceed.
Now I will
Thank you.
The correct motion. In the case of W17-003 subdivision exemption land development code amendment, the county commissioners have reviewed the staff report, including all exhibits and attachments, and have listened to the applicant's presentation and any public comment as presented at the public hearing. I hereby move to approve this application based on the findings in the staff report, subject to the following condition. Number one, staff will make corrections and revisions to the proposed language as directed by the county attorney prior to incorporating the approved amendment into the Land Development Code for publication.
Motion made by Commissioner Sharp, seconded by Commissioner Jackson. All in favor? Aye. That motion passes unanimously. Thank you very much. We are moving on to general business item, and this is the planning fee schedule update. Again, we have presenter Jason Reynolds, and our attorney is Mr. Bob Hill. Mr. Hill, would you please lay the foundation for this?
There's no required public hearing involved with this. The board has jurisdiction to proceed. It's been noticed through the general posting for the public meeting.
Good morning again.
Good morning, Mr. Chair, members of the Board of County Commissioners. This is a proposal to amend our existing planning fee schedule, as well as through the proposed motions make a couple of changes to the engineering services fee schedule. The primary goal is to reduce the total fees for subdivision exemptions from $3,500 for both planning and engineering to a $2,000 total fee. Secondary goals are to update the fee schedule with current case names, as well as to establish some fees for services such as development agreements, the vesting of development plans, and extensions of time to file final Mylars. And our hope is that this lower subdivision exemption fee would discourage fee waiver requests for those types of applications, because as the board knows, several people have been surprised by needing some form of subdivision and have requested fee waivers from this board and often received them. The proposed fees do account for the estimated staff effort for the type of case. For example, the development agreement requires a single public hearing, which is similar to the comprehensive plan amendment fee that one is modeled after. And one fee that's proposed that wasn't mentioned in the staff report that I'd like to highlight is the extension request fee of $100. It's on the first page of the proposed fee schedule at the bottom. And what that is an applicant is required to submit final plans in Mylar form after Board of County Commissioner approval within a certain amount of time, depending on the case type. Typically, it's 90 days. It can be up to 6 months, I believe. And the code allows the planning division manager to grant extensions in some of those cases, but that requires the planning division manager and admin staff to prepare a letter, to proofread the letter, and send it out. And it's analogous to the fee we charge for a zoning verification letter. So the proposed fee for that would be $100. And staff does recommend approval of the proposed fee schedule, and the draft motions also include conditions that adjust engineering services fee schedules for subdivision exemptions as well as administrative solar cases. So I'd be happy to answer any questions that the board may have.
I had one question. I noticed that one of the Eastern End Planning Advisory Committee members had mentioned that there was some concern that property taxes would be going up as a result of this. And while I don't believe that's true, I don't believe this has any impact at all whatsoever on the property taxes. Just kind of a general rule. Do we get back with those folks and kind of answer their concerns when they have something that really is out of sync with what the intent of the proposal is doing?
In this specific case, I don't recall getting back to that particular member of the East End Advisory. And you are correct, sir, that this should not affect property taxes. Though if somebody does get an exemption and their property is only 5 acres in area, it's unlikely that they would be able to get the agricultural exemption, based on the property size and the use. However, the assessor bases that exemption on the existing use of the property, and they don't really look at the zoning aspects of it. So it's likely that something that size wouldn't be getting that agricultural exemption anyway.
Good, thank you. Any other questions? Commissioner Jackson.
Yes, again, thank you for this. It's, excuse me, we've been working on this for a long time, so appreciate you bringing this forward. I just want to double check and make sure we have kind of a motto that development has to pay for itself. And so I just want your reassurance that this is within that philosophy, and that we certainly want to be fair and not overcharge, but we also have to pay for the work that everybody puts in. So can you give me that reassurance that development is indeed paying for itself?
Yes, Commissioner, I can, with one notable exception, and that's the proposed subdivision exemption fee. Those fees are probably lower than the amount of staff time required to prepare staff reports and do the case management. However, the goal with that one was to put the fee at a level where people would be willing to pay it, because in several cases we collected $0 for a similar process. So something is better than nothing.
Yeah, in that case, it's kind of healing an old wound or fixing something that was broken previously. So I think that I, for one, would certainly not, well, I mean, I already just voted for that, but I think that makes sense, and I think that's in the spirit of how we want to conduct business at the county. So I'm happy to make a motion unless other people have comments.
Please proceed.
All right. Well then, this motion doesn't have all the usual stuff. I'll just read what it says. In the case of 2018 planning fee schedule update, the county commissioners have reviewed the staff report, including all exhibits and attachments, and we have listened to the staff's presentation and any public comment as presented at the public hearing. I hereby move to approve the 2018 planning fee schedule update with the following conditions. 1, the Engineering Services Division review fee schedule shall adjust the subdivision exemption fee to $1,000. And 2, the Engineering Services Division review fee schedule shall add a $500 fee for administrative solar cases.
Motion made by Commissioner Jackson. Seconded by Commissioner Conti. Even though this is not a public hearing, I just want to ask if there's anyone here to address us on this issue. Seeing none, motion made by Commissioner Jackson, seconded by Commissioner Conti. All in favor? Aye. That motion, any objections or abstentions? That motion carries unanimously. Thank you. This brings us to the end of our public meeting. Are there any commissioner comments this morning? Commissioner Holden.
Thank you, Mr. Chairman. I attended on last Friday the dedication of the Century 21 memorial to the victims who were sadly killed in the theater. The architect and sculptor was there with a very meaningful and uplifting message as to the theme of the memorial. It's a series of storks, or series of cranes flying up in a formation towards the heavens, followed by various cranes around the monument, symbolizing those who survived and the first responders who saved many, many lives. I think it's important that we recognize the tragedy of that event, and that we encourage our citizens to come to the park in front of the municipal building in Aurora to reflect upon the tragedy and the long-term impact of this tragic event. Thank you.
Thank you, Commissioner Holman. Any other commissioner comments? If not, we are adjourned.
Downstairs. Yeah.
Downstairs.
Downstairs. Pikes Peak.
Yep. That's